Anyone who holds a license for real estate in Georgia is bound by the rules issued by the Commission. The Commission has broad powers, including the right to revoke, suspend, or issue a real estate license to any person, as well as the right to regulate the rules pertaining to the issuance of a license. The Georgia Code grants the Commission the following powers. The Commission can regulate all licensing matters, including the issuing, suspension, revocation, and censure of any licenses. Each applicant agrees that the Commission has this power as part of their initial application or application for renewal. In addition, should the Commission feel it is necessary to investigate or examine a broker's trust account, they have the authority to hire or enter into a contract to assist them with the fulfillment of such examination. There are some limits on this authority. However, since the Commission must be able to demonstrate, such examination requires specific expertise, including that of an accounting or legal expert. In these cases, the Commission maintains full supervisory authority over such experts. Final decisions in any cases are made by the Commission and not by any expert whom the Commission hires to undertake the review. It is important to remember the Commission has broad power to collect fees as well. The fees may be used to pay any and all fees required to pay such experts, provided that any funds remaining at the end of the year are turned over to the State Treasurer for deposit to the State Treasury. No fees remaining at the end of the fiscal year may be carried over from year to year. One of the more serious responsibilities of the Commission is establishing what behavior is acceptable for those who are license holders. The Commission has previously established it is the responsibility of the real estate license holder to act in the interest of the public. Therefore, license applications are reviewed and will not be approved should the applicant have a prior felony conviction. It is also worth noting the Commission has determined that should an applicant have pled no contest or agree to treatment as part of a first offender program, this person may also be denied a license. The Commission may review applicants at their discretion should more than 5 years have passed, and the applicant has fulfilled their debt by fulfilling the terms of any jail time, restitution, etc., which were the result of the conviction or arrest. The Commission retains the right to insist that applicants with a prior conviction be able to effectively demonstrate they have successfully established their competence, honesty, and can demonstrate they can be trusted. The Commission has the sole discretion to request such documentation and has the authority to determine how the applicant must document their claims of having rehabilitated themselves. In cases where the applicant is applying for an associate broker or a broker's license, should there have been a conviction involving a financial crime or one of moral turpitudes, the waiting period before being reconsidered will be 10 years. The 10 years begins at the time of conviction, release from incarceration, or fulfillment of sentencing, whichever of these events occurs last. False statements, violation of fair housing law, or pending criminal charges shall be grounds for denial of a license and, in some cases, for refusal to issue a license at any time. Should an active licensee be convicted of a crime, the Commission may suspend their license within 60 days of the conviction. Additionally, license holders who are facing mortgage foreclosure or are in default of child support payments will also have their license suspended, or an initial or renewal license application denied. Such suspension or denial shall continue until such time as the applicant has made appropriate arrangements to address the issue. Applicants for a real estate license may have the opportunity to rebut a denial, revocation, or suspension of their license through a hearing. These hearings will take place in the location where the Commission has established their primary place of business. Should an applicant not be satisfied after such a hearing, they may be entitled to request the Superior Court of Georgia to review their case. The court review will also take place in the county where the Commission does business.